very famously, Booker T. Washington, in his Atlanta Compromise address, argues that the advancement of African Americans in this country should be based on their entrepreneurship and not on dismantling Jim Crow. Now, there were other African American leaders who persisted. W.B. Du Bois, for example, some others that really still continue to hammer away at dismantling the system of social inequality. But it appears that, at least for a while, the position of Booker T. Washington was the predominant position. So you've got the politics that changes pretty dramatically. It really just sort of reverts to the pre-Civil War politics that had existed. Why did that happen, by the way? Well, I gave you an explanation for why it changed so dramatically during the Reconstruction period, right? African Americans were enfranchised, white Confederates were disenfranchised. What do you think began to happen as Reconstruction comes to a conclusion in 1875? White get re-enfranchised, right? Not only the right to vote, but also the right to hold public office again. They start getting elected to state legislatures. They start getting elected to the United States Congress and other offices. And they are interested in reestablishing dominant white society. And that's essentially what happens. Let's talk, though, about the constitutional matter, the civil rights cases of 1883. Remember, this involved the Civil Rights Act of 1875 that Congress had passed and provided penalties to private operators of public accommodations for discriminating on the basis of race. The question goes before the Supreme Court in 1883, does Congress actually have the authority under the Constitution to do that? Okay. Do you think Congress believed that it had the authority to pass that legislation in 1875 when it passed it? Sure. I mean, obviously, we can't go back in time, but I think that if we could, when we were to survey the members of Congress in 1875, hey, do you think that Congress actually has the constitutional power to pass this legislation you're about to pass? I think they'd say, of course. Right? Or do you think they would say, maybe I'm wrong? Maybe they would say, no, we don't actually have the constitutional power to pass it, and we're going to pass it anyway. I think it's more likely the first, right? Okay. And on what basis in the Constitution do they think they have that authority? Does anybody remember? We've talked about something here in today's class meeting that might give them the idea that they have the authority to pass such a law.
An enforcement clause?
An enforcement clause?
Or it says Congress to enforce the 14th Amendment.
It's actually the Section 5 of the 14th Amendment, right? It says here, Congress shall have the power to enforce by appropriate legislation the provisions of this article, the intent of which I told you was to ensure equal rights and non-discrimination on the basis of race. It's very clear that that's what the intent was of the framers of the 14th Amendment, to prevent discrimination on the basis of race. Right? So I think, yeah, Congress clearly thinks it has the authority. Now, look, here's something we haven't had a chance to talk about yet, but, we're getting very close. We're already there in our reading, but we're getting very close in our class sessions to talking about the Constitution more generally. And one of the things that we're going to say when we talk about the principle of federalism is that the national government under the Constitution, the national government is a government of enumerated or delegated powers, authority that is granted to it by the Constitution. And any authority that's not granted by the Constitution to the national government is authority that's reserved to the states by the 10th Amendment. That's what the 10th Amendment says. The 10th Amendment, added to the Constitution in 1791, says that any power is not delegated to the national government or reserved to the states. So why in 1868 did the framers of the 14th Amendment think they had to put this language in there? Oh, because if Congress is going to undertake a legislative agenda to promote racial equality, then we're going to have to give Congress the authority to do that. That's exactly why that language appears there. And that's why Congress thinks that it has the authority under the Constitution to do it. However, the Supreme Court disagrees. The Supreme Court says in the civil rights cases of 1883, come on. This just doesn't want to cooperate sometimes. That the 14th Amendment does not give Congress the authority to do that. Okay? I'm not going to read this whole thing to you, even though I'm tempted to do that. So let me just say to you that what the Supreme Court says in its decision is that nothing in the 14th Amendment gives Congress the power to punish private individuals for discriminating on the basis of race. Instead, what the 14th Amendment does, I need to put a link in there. If we look back at Section 1, it doesn't say anything in there about private individuals, does it? What it says is the states, nor shall the states deny to any person within their jurisdiction the equal protection of the laws. So what Congress has the power to do is enact legislation that would prevent the states from discriminating in their official acts on the basis of race. Doesn't say anything about private individuals. So if we're going to have laws in this country, the Supreme Court seems to be saying, if we're going to have laws in this country that punish private individuals for discriminating on the basis of race, they're going to have to be passed not by Congress, but by who? Or by what?
States.
The states. And the political reality is that states like Mississippi and Alabama and Georgia and Texas, South Carolina, none of these states, the legislatures of which have any political will whatsoever to pass those kinds of laws.